We're still missing one, right?
City? They're here. I don't know what their guidon is. The guidon.
They're still submitting central. To what? Are they, are we, I mean, are they here though? I mean, where would they?
Like their guidon's not here, but like the city itself is here. I want to say Lauren, but I'm not 100% sure. Levi. Nope, it's not Lauren. It's Lauren right there. McCollum's right there. Will's right there. Summers right there. Maddox. Hammer's right there. That's Kane.
At ease, gentlemen. At ease. Let me have everybody's attention. I'm trying to make sure if we're up, if we got everybody, but I'm showing we're missing a guidon. Do we know, are we missing a city? Are we still a city short?
It's up here.
It's, okay, you got it up there. Then we're squared away. All right, we'll go ahead.
Go ahead.
More Tennesseans are turning to the state's best public university, Tennessee Tech. Tech produces bold, fearless, confident graduates who get an outstanding return on investment, who graduate with the least debt in the South, almost half with no debt, earning higher mid-career salaries than graduates from other public universities.
Tennessee Tech, just like our state, is soaring to great heights. As president, I encourage you to learn more about Tennessee Tech. We transform lives every day. Tech is Tennessee.
All right, so today's presentation is going to be by Assistant District Attorney General Caroline Knight. General Caroline Knight was born and raised in Bledsoe County. She graduated Pace University with her Doctor of Jurisprudence in 2006. After being a solo practitioner, she joined the District Attorney's Office in 2011. She has prosecuted cases ranging from DUI to first-degree murder. She currently oversees the prosecution of all major felony child abuse cases in the 13th Judicial District. Please welcome General Caroline Knight.
Thank you. Good morning. How is everybody this morning? Can you hear me okay up top? I'm wearing a lapel mic, so if we get a little feedback, just bear with me. Thank you, Judge McKenzie, for inviting me again this year. Thank you, Governor Norris, for the introduction. I am a prosecutor here in the 13th Judicial District, which of course includes Putnam County. The counties toward the center of the state there in yellow are my district: Clay, Pickett, Overton, Putnam, DeKalb, White, and Cumberland. I'm originally from Bledsoe County. So I've been asked to come back this year and talk about cyber citizenship. Talk a little bit about sexting, cyberbullying, talk about some sensitive topics this morning. We're going to look at why is it such a big deal that we cover this? And I'm going to ask for some assistance. Front and center, is anybody right here on the front row wearing a watch this morning? May I ask you, sir, what's your name? Will, would you be my timekeeper this morning? Would you give me a halfway warning at 11:15? And would you give me another warning at 11:35? I think that will allow us about 20 minutes at the end for questions and a little bit more interactive level of participation. Judge McKenzie has let me know that you all had a great deal of questions last night, and so he condensed his presentation some in order to accommodate that and suggested that I might do the same. In preparing to speak with all of you today and in consideration of the subject matter that I was asked to speak about, I took a quick look at your policy manual here for American Legion Boys State, and one of the rules that I found actually applies directly to what it is that I've been asked to talk with you about this morning. Rule number 10 prohibits inappropriate use of cameras, imaging, and digital devices, especially use of those devices in areas where privacy is expected by participants. That closely parallels with a state law that we have here in Tennessee. Tennessee Code Annotated 39-13605 is our unlawful photographing statute. Photographing in violation of privacy. So what constitutes that crime? As you can see, it's a crime to photograph someone when they have a reasonable expectation of privacy, and in the case of minors, without the consent of a parent or guardian, if the photograph, one, is embarrassing or offensive, and two, is taken for the purposes of sexual gratification. So, what would the consequences for that particular crime be if committed here in Tennessee? Typically, it's a Class A misdemeanor, and I know that you all are learning about government processes, the difference between civil law and criminal law, and I'll just ask you to shout out if someone would volunteer the answer if you know. What's the penalty? What are the consequences if convicted of a Class A misdemeanor? Anyone? I think I heard it toward the back middle of the room. 11 months, 29 days is your maximum punishment. This crime, however, can become a more serious crime. It can bump up to a Class E felony if the photograph is disseminated. What we really mean there is distributed, sent out, or shared. Or if the victim, the person depicted in the photograph, is 13 when the photograph is taken. Now you can see that our legislature treats even more seriously circumstances where the photograph is shared and the victim is 13. That then becomes a Class D felony. So between a D and an E, which one's more serious? And does anyone know the range of punishment for a Class D felony? I think I kind of hear it. There is a range of punishment, but 2 to 6 years is a range for conviction on a Class D felony. So, as we move through this presentation, I would ask you this question: what is your biggest threat online? People, someone volunteered the answer. Think a little closer to home. Perhaps I should say, who is your biggest threat online? You. You are your biggest threat online. We'll get a little deeper into that this morning. So, you'll have to forgive me with all the royal wedding excitement. I couldn't help but pay a little bit of attention. And I was fascinated with the media coverage of things leading up to and during the royal wedding over the weekend. And I'm particularly interested in the rules of comportment and decorum that were attached to that. And behind it all, it seems as though Queen Elizabeth II is sort of the embodiment and maybe the invisible hand guiding a lot of those rules. And so I've devised a very simple, informal, unscientific, but I think fail-safe test. In considering your own actions online, just ask, would QE2 approve? Who is this guy? Exactly right. Thank you very much. And so he is originally a congressman, Democratic congressman from New York, and he's also a convicted felon. Why is that? Exactly right. And so, we will use the term sexting. Another legal way to put that term is solicitation of a minor. And we'll talk about his crime, and he was punished federally. You all are also studying, I think, separation of powers, federalism, and things like that. And so, as I said, he was a former U.S. congressman. He's now a convicted felon. He's now required to permanently and for the rest of his life register as a sex offender. And I've got some other details up there, but I'm sure you all are fairly familiar with the history underlying his conviction. And so if you look just to the portion there that I've highlighted, he had full knowledge that he was communicating with a real-life 15-year-old female, and he asked her to engage in sexual conduct via electronic means, which were Skype and Snapchat. She did so. Her body was on display, and she was asked by him to perform sexually for him. Now, that was prosecuted federally, but as we look at some of our state laws here in Tennessee, you'll start to see that they very closely parallel. The sentence that prosecutors asked for in this particular case was between 21 and 27 months. He got 21 months in federal prison as a result of his actions. Would QE2 approve? No, Mr. Weiner. These are our sexual exploitation of a minor statutes in Tennessee, and the layman's term, as volunteered by the upper balcony there, can be sexting. But Tennessee Code Section 3913-528 is our solicitation of a minor statute. 529 is solicitation of a minor by electronic means. We have 3917-1003, which is sexual exploitation of a minor. In layman's terms, items that are materials that depict minors engaged in sexual activity. Layman's terms, that's known as child pornography. Question that I'm sure everyone here knows the answer to. A minor is anyone below what age? 18. And an adult is anyone. And you'll see that some of our statutes focus particularly on those age distinctions. So solicitation sounds a lot like asking someone to do something. Do we agree? Sounds a lot like our convicted congressman's actions. Making sense so far? So if you have an adult who, by means of electronic communication, solicits, asks, requests a minor, or a law enforcement officer posing as a minor to engage in sexual activity, then the crime of solicitation of a minor is complete. You'll see that there is no defense to this crime if the solicitation is unsuccessful. In other words, if the minor does not comply, the crime is still complete. So examples of this occur via cell phone text messages, in chat rooms. Solicitation of a minor by electronic means or electronic communication, again, is when an adult, someone over 18, causes a minor to engage in sexual activity, or the offender, the person charged, engages in sexual activity in view of the minor, or in the case of some of our undercover operations, when it's a police officer that the suspect believes to be a minor. So a good example of this would be what kind of electronic device? Exactly. Thank you, sir. What's your name, sir? John? Did you say John Wayne? All right. Thank you, Mr. Wayne. And so let's talk about the punishment on conviction. Some of us get really cool names that, depending on the crime that is solicited by the offender, the level of offense could range from an A misdemeanor all the way up to a B felony. And at range 1, the punishment on, if convicted on a B felony, is 8 to 12 years. With these crimes in Tennessee, registration on our state sex offender registry is mandatory, and it is a lifetime registry requirement. I'm sure all of you are familiar with, to some degree at least, the sex offender registry. It's a public list of known and convicted sex offenders that live within the state. You can search through there. And of course, there are rules and prohibitions against where these people who are convicted of these crimes can live, work, things of that nature. Sexual exploitation of a minor, possession of child pornography. Now, I want you to pay a little bit of attention here, because you're going to start to see a distinction between an act by someone who's an adult or an act by any person. So the plain language of this statute, and I quoted it here, states, "It is unlawful for any person to knowingly possess material that includes a minor engaged in sexual activity or simulated sexual activity that's patently offensive." So without the age exception, who could the sexual exploitation of a minor statute apply to? Anyone. All of you. Agree? Anybody disagree with my contention? So when you look at how to punish this crime if convicted, it really turns on the number of images possessed. Under 50 images is a D felony. We've already talked this morning that that is a 2 to 4 year range of sentence. Over 50 images is a C felony with a 3 to 6 year sentence. And then over 100 images is a Class B felony, and that's our 8 to 12 year range. An additional distinction with the B, because it is the most serious of those crimes, is that it is a what we call day for day or 100% sentence. That means that there is no parole eligibility for someone convicted of that B felony crime. In a prosecution, and I do handle internet crimes against children cases in my duties, I, as a state, do not have to prove the identity or the age of the minor victim that's depicted. Aggravated sexual exploitation of a minor is really our distribution statute. So a person who distributes, sells, promotes, purchases, or even possesses with the intent to do one of those things has committed the crime of aggravated sexual exploitation of a minor. You'll see that it's treated out of the gate as a more serious offense. Conviction there starts out at that C felony range. That's for less than 25 images. More than 25 images bumps that person convicted up to a B felon. someone that is actively filming, making, or producing child pornography. That's also a B felony. That crime is especially aggravated sexual exploitation of a minor. And again, that's what we call a day for a day or 100% sentence. So I looked at your creed, and among the paragraphs there, it clearly states that American citizenship is my most priceless possession. Conviction of any of the crimes that we are reviewing today would have a direct and negative impact on your ability to participate and contribute to the political welfare of your community. So the things that we're reviewing really do tie back to that creed. How are some ways that conviction would prohibit you from having that meaningful participation in your community? Just volunteer. Yes, sir. Right hand raised. Tell me your name, sir. Huffman? Humphrey? I'm sorry, it's hard to hear. Mr. Humphrey, could you repeat your answer? Absolutely. How about other ways? Does anybody have an interest in the future in running for political office? Lots of hands raised. Second here on the second row. What's your name, sir? Amos? Mr. Amos? How do you think this might affect your ability to do that if convicted? Well, and if you're convicted felon, do you have the ability to run for elected office in our state? So it goes even further than that. Thank you for volunteering with me. So our state constitution sets out your loss of right to vote if felony convicted. Can't hold public office. Mr. Amos would be out of a future job. You also lose your right to serve on the jury. Can't possess a firearm. And then, as Mr. Humphrey pointed out, you've got these sex offender consequences that you carry with you. So choose your words carefully here, but what is sexting? Yes, sir.
I believe sexting is when you take an inappropriate picture of somebody or yourself and
Mr. Wayne, that's a perfectly legally acceptable answer. Thank you for volunteering with me. So, is it really that big of a deal? It is. And so, in Tennessee, those photos that Delegate Wayne has described, those are crimes. It's considered to be child pornography. So that would apply, yes, to all of you under the age of 18 who takes a photo, distributes a photo, or if you simply possess a photo. And so you all can provide better examples than I can, but I'm sure that you're aware of situations where this has occurred and the reasons that underlie that. Example, anybody? Yes, sir.
so let's just say like somebody was doing it to them, I guess to make them feel good better and they get into the wrong hands and then they try to like blackmail them or cyberbully them, like instead of them like.
And you've already described a situation where multiple people along a chain, your answer includes getting into the wrong hands to make somebody feel better, then you've got potential multiple violations of that crime by multiple people. Do we agree? So how do people find out about this? What's your name, sir?
My name is Mason McCain. I have a question.
Yes, sir.
What if a minor tries to engage in like sexting with an adult? Does the minor get in trouble?
Well, what do you think?
I feel like it should be accountable for their actions.
Okay. And so your last name was McCabe? McCain? Okay, thank you, Mr. McCain. Let me try to answer that. We've looked at our solicitation statute, and so it's very clear, I think, that the hypothetical that you present would amount to a violation of that Tennessee crime for the adult. Do we agree?
What if the adult doesn't like it? They like walk and then like turn it in?
Okay. Okay, so the adult's not the one asking, The adult is not a knowing, perhaps, participant. Do I understand your question? So there are some, that's an excellent question. There are some laws that are currently being looked at by our state legislature. Know that for most crimes, if committed as an adult, there's a corollary delinquent act or unruly act that a juvenile can be prosecuted for. So you're absolutely thinking along the right line, and I'll show you one of those laws that the legislature has been working on in just a moment. Is that a satisfactory answer for now? Thank you. And so, other ways that people can find out that this crime is being committed would include a search warrant. Now, show of hands, how many of you were assigned the criminal case in your case materials for this week? Don't have those yet? Okay. Are you doing your case law review this afternoon? All right. Those of you that are assigned the criminal case, I think that you'll find that one of the issues in the case has to do with an investigation into the crime of sexual exploitation of a minor and the search warrant that was used by the investigator to try to gain evidence of that crime. And we have a statute in Tennessee that says no process shall issue unless the district attorney signs off on it. And so those of you that have the criminal case today, that's going to come up in your afternoon session. So just know that that is another way that these crimes can come to light. So we know that if you're caught, you can be charged potentially as a juvenile, and obviously adults we've established can be charged in criminal court. Potential loss of scholarships, financial aid opportunities, sex offender registration. Now once you've disseminated, distributed, shared something online, when does that go away? Never. It's always there. And so the advice I would give is to make educated decisions about what you choose to share. Look at the material as though a prospective employer, prospective voter, other people in the public might someday also be looking at that. Obviously, you could expose yourself to blackmail, school discipline, even police involvement. So consider this. This is from Florida, but it's a good example. Philip Alpert was 18 years old at the time, teenager living in Florida, and he was placed on the state of Florida's public sex offender registry because when he and his girlfriend had an argument, she was 16, she forwarded images that they had shared, he forwarded images that they had shared to other people. And so he'll be on the state of Florida's sex offender registry for at least 25 years. If you Google him, that's what you find. Would QE2 approve? The photo cut off, but actually online she's grasping at her heart as well. So it does not pass the QE2 test. So if you become aware of these things going on in your schools or in your communities, what are some things that you can do to try to protect the victim of that crime? Tell someone. Any authority figure. Educate your friends. Tell a parent or a teacher. I think this is all pretty common sense stuff for this portion of the presentation. If you boil it all down, it's really to just stay in control. And don't take images of yourself that you wouldn't want everyone to see. And just don't forward anybody else's image, ever. If you follow that rule, then you're never going to be in danger of violating any state laws. We do have a mandatory reporting statute in Tennessee. It applies to everyone, all of us. Anyone who becomes aware of either known or suspected child sex abuse is a mandatory reporter under this statute. It means that you have to report by telephone to DCS. There's a 1-800 hotline to make that report. And if you have that knowledge and you fail to report it, That in and of itself is a crime. It's a Class A misdemeanor. Give me some examples of cyberbullying. How about just posting mean things? Does that rise to the level? Can? Creating hate groups sound like cyberbullying to you? Photoshopping someone else's photo for the purposes of embarrassing them? Consider that when we get to some of our telephone-based crimes in just a moment. Cyberbullying also includes recording and posting fight videos, spreading rumors through text messages, stealing someone's identity to make a fake profile. So we have a harassment statute in Tennessee, applies specifically to telephone and electronic communications, 3917-308. And so making threats by electronic communication, which of course includes things that we've already covered, text messaging, email, internet services, all of those can be criminal acts. And in addition, one or more telephone calls without any legitimate purpose also amounts to a violation of our harassment statute. In addition, displaying an image that threatens harm to another person is a violation of this statute. This is a Class A misdemeanor. Maximum fine for a Class A misdemeanor is $2,500, and we've already discussed the possible 11-month, 29-day punishment or sentence that a Class A misdemeanor carries. So I could only find one new law effective this year that had direct bearing on my presentation today, but it's kind of indirect, but you can't make cell phone calls in school zones as of January 1 of this year. It's a Class C misdemeanor to do so, punishable by a $50 fine. You can, however, talk on your hands-free devices. 11:15, we're halfway. All right, thank you very much, timekeeper. If we look at some of the legislation as a review over last year, we have and this applies actually directly to the question, the hypothetical posed by you, sir. The legislature's working on a statute, and this was proposed last year, and it would make illegal use of a communications device by a minor a delinquent act, so that's punishable in juvenile court. If a video or photograph or other material was created, received, or exchanged, and the material showed a minor in a state of nudity. And so you can see that that's a much lower threshold to meet to commit that crime than actual sexual activity or simulated sexual activity. And so this did not pass exactly as drafted. The working draft of this got moved to this current legislative session, and on May 8th, a very similar law was passed. I don't have that language. I was working on that this morning because it's so recent. It makes it an unruly act, the law that actually has passed as of this month, if it's sexually explicit. So the proposed law had state of nudity, which the threshold would be lower. Sexually explicit would be more in the middle if we were making a scale between nudity and sexual activity. And so that is a unruly act, now punishable by law in Tennessee. Does that answer your question now fully, sir? And so the legislature also saw fit within the last year to expand the harassment statute that we just looked at. And someone, I think up top, had offered the suggested example of revenge porn in response to the question about cyberbullying. And so our harassment statute now includes transmission or display of an image via electronic means if there's malicious intent to harm the victim, the person that's depicted in the image, and any reasonable person would perceive that image that communication to be a threat of harm. So I think it should be pretty clear that the legislature is working hard to try to catch up and expand the law in conjunction with developments in technology. And it's a challenge to stay on top because technology is always evolving. The legislature also added, when we began, we looked at the unlawful photographing in violation of privacy statute. The legislature has also recently made this a crime for which, if you're convicted, the sentencing judge has the discretion to put you on the sex offender registry for commission of that crime. Even though the crime itself is only a misdemeanor, you can see that that additional and higher consequence has been added. So if you're a victim, a very basic strategy is not to respond and to block the person that's attempting to communicate with you. Set up new accounts and make a report. Talk to someone. All common sense stuff, nod your heads, thank you. I think we've covered this. Don't encourage others to engage in this behavior. So if you look at some of the CDC statistics, particularly as they apply to deaths among teenagers, there's a theme that starts to emerge. And so among teenagers, suicide is actually the third leading cause of death. There's about 4,400 deaths per year. This is just a CDC statistic. And victims of bullying are somewhere between 2 and 9 times more likely to consider suicide than non-victims. That's according to a study by Yale University. So you can see that the consequences are actually really far-reaching. Once on the internet, forever on the internet. That's a quote from Eric Schmidt, who's the executive chairman of Google. Think about who might see your pranks or your party pictures, any nude selfies that you share or posted. Basically, all of those things just document poor decision making, and I don't think any of you want to do that. But they can be proof of criminal activity, and that's the main point that I want to illustrate with you all this morning. We covered most of these in the consequences. May come up in college application reviews. Certainly could affect your sports eligibility and your reputation moving forward. Could have negative consequences for your social life. Obviously, the list goes on. Would QE2 approve? Oh, excuse me. And so I know we're just a little shy of the mark, timekeeper, but seems like a good opportunity to open it up to questions. I think we'll have maybe 20 minutes to kind of do that. And I think some of our leaders will assist us by having some portable mics maybe. And I'll do the best I can to answer questions that you may have. If you do have a question, if you might stand and come to the aisle, and then they can identify you. Okay. So,
Test. Test. Hello.
yeah.
Hey! All right, go ahead.
All set, Governor? Thank you, Judge. So I may just alternate, and then can I get you to help me keep an eye on that time still? Just let me know when it gets to be about 11:45. Thank you. Let me start with you, sir.
So you said that you don't have to verify the age of the child in the case? case.
Yes.
So how do you prove that it is a minor in
Yes,
the pictures?
and I'm backing up from you because of the feedback. So what's your name, sir?
Justin Humphrey.
Mr. Humphrey, thanks so much for your participation this morning. Mr. Humphrey's question, for those that maybe didn't hear, is if the state doesn't have to prove the age of the minor depicted in an image that's sexually exploitive or child pornography, then how do we ever reach that decision? Is that correct? So in Tennessee, what a prosecutor has to do as part of their case is actually show the image or images that they've identified to the jury. And we know in Tennessee a jury is how many folks? It's 12. And in Tennessee, can it be a majority vote or does a jury decision have to be unanimous? Yes, Mr. Humphrey, it has to be unanimous. So all 12 members of the jury would have to unanimously agree based on the image that they saw that the child depicted was less than 18 years of age. Now, there may be other contextual evidence that a prosecutor has at their disposal that corroborates the argument that the child is under 18. And I don't want to be very graphic this morning, but an example might be within search terms or file names. For example, if the defendant has searched a term preteen hardcore, then that is at least corroborating evidence that that victim is under the age of 18. Fair enough? Thank you. Come over here, please.
I just want to know.
Tell me your name, please.
My name's John Amos, and I just
Amos.
want to know your feedback on my friend.
Is it
Yeah.
bad?
Yeah, I can. My friend, he was 17 and he was dating a 16-year-old girl. It was on his 18th birthday they had sex, and their parents caught him, and now he's a registered sex offender. So I just want to know your feedback on situations like that.
Okay, so you saying that as an adult, he was convicted of a crime that put him on the registry. Is that,
He was 17 when they started dating, but he turned 18, they had sex, and now he's a sex offender.
okay. So sex without consent, I'm going to give you a broad answer. Sex without consent is rape. That's a Class B felony. It's classified as a violent sex offense. Get you on the registry, absolutely, and for your lifetime. I think what your question sets up is a little bit, perhaps, different set of facts where consent may not have been the issue, but you're looking at a potential statutory rape crime. And so in investigating crimes of that nature, the state prosecution always relies on investigators. Hopefully the jurisdiction has a special victims investigator that's tasked with investigating those types of crimes. They're very sensitive. And typically what's required to make out the crime of statutory rape is a 4-year age difference. That's usually the bare requirement. If you have someone that's under 18, the victim, and a defendant who's more than 10 years, then that's an aggravated statutory rape. So I'm not sure of all the facts in your question, but I can tell you that during the investigation, those are a case-by-case, fact-based analysis on what crime has been committed. Does that make sense? I'll come back over here.
My name is Preston Beatty from Stone Memorial High School, and I was wondering, in the case of the 18-year-old from Florida, whether or not the victim faced any charges for sexting him in the first place.
Not that I'm aware of. I don't have any information from my research that suggests that there was a corresponding crime or delinquent act in Florida for the girlfriend. From Cumberland County? And tell me your last name again?
Beatty.
Mr. Beatty?
Yes.
Thank you so much
Thank
for
you
your
very
question. Delegate Wayne.
John White again, from Northeast High School. I was just going to ask, dealing with the Class B felony, have you ever had to judge someone who had that 100 amount of pictures? How gruesome was it? What was the experience like?
All right. I can think of around 5 currently indicted cases where the investigation yielded numbers of images that far exceeded 100. And I take no joy in having to review that evidence. I take it seriously, but I do not I do not like it. And what my strategy is personally is to try to do a thorough review but minimize my own exposure to the content. And if in the review there's clearly 100 images within the first few files reviewed, and I believe that a jury could unanimously agree that each of those is a violation of that crime, then I might rely on what the investigator has to tell me about the remainder of the images and not have to pore over those as well. Because I don't have another enhancement. I don't have an additional crime under these facts that I could charge. Does that make sense, sir? Thank you. I'll come over here. What's your name, sir?
I'm Colin Robinson. I had a quick question. It's not about like sexting or anything, but like right now there's like something called Vine or like memes where you can like post embarrassing videos of people and it's like really funny. But like, what if that person who it's the video it's about, like they get mad and they want to sue? How can you like, you know, be a prosecutor in that when you can't find the originator of like the video? It's
Okay.
like a trend.
So I'll give that a shot. That's a fairly complex question, but I think it's very relevant to things that are going on in the world today. We know there's a distinction between civil law and criminal law. I'm solely on the criminal side. If it didn't rise to the level of at least a misdemeanor harassment statute that we looked at, then it might not be prosecutable as a crime. That certainly wouldn't prohibit the victim from suing for many civil wrongs. But what's interesting about things that we post online, whether it be, you're really talking about videos on Vine, right? Videos, photographs, all of those things contain embedded data, metadata. Do you know a little bit about what I'm talking about? And so in investigations that I work on, I have electronics forensics expert investigators that I'm fortunate to work with. And so if a cell phone was seized, for example, even if it were a discarded cell phone that an owner had tried to abandon, there's a lot of information contained within that phone such that I think it would be very difficult for that person to hide or evade from a prosecution. The investigators that I work with can recover data so small as to include the location that a photograph was taken, the date and time it was taken on, if it was taken on a digital camera and then downloaded or shared with a cell phone. The device that initially took that image will have identifying information within that metadata. And so I think it would be really hard to evade prosecution if we could make out a crime under those circumstances. And that really relates back to internet safety in general. It's not necessarily always a great idea to take a picture of yourself wearing your high school Letterman jacket standing in your yard at home, because a potential predator would have obvious information to identify you with, but they could also look in that metadata and get a GPS bird's eye view of your backyard. So those are just some things that relate to internet safety to bear in mind. Thank you for your question. What's your name, sir?
Hi, Nate Morgan from Summit High School. I remember earlier you were talking about how if a phone call is considered annoying enough, it can be considered harassment. Does that apply to phone solicitors as well? And also in the digital sense, could that roll over into spam emails and scams?
Okay. So the answer potentially to both forms of electronic media is yes. Now, it is much more difficult in the instance of, say, a robocall to go back and track down who it is that's making that call if you compare that to the previous question with a Vine, a video online. But with that legitimate purpose, under our circumstances, it's going to come down to a jury question. And so if you could identify that harassing solicitor and a jury agreed that that call was without legitimate purpose, then potentially yes. Potentially. Yes, sir. Thank you for your question. Yes, sir.
My name is Hasadai Coleman, and I'm from Henry County High School.
Mr. Coleman, thank
Yes,
you.
ma'am.
Good morning.
Good morning. I'm wondering whether or not it's possible or has ever occurred for someone to have, say, gotten a Class A felony for soliciting a minor.
Okay, that's a terrific question, and you were paying attention because the slide said that there's a range there and it depends on the underlying crime solicited. And so an example that would get you very close to that would be soliciting the crime of rape of a child. Rape of a child is penetration of a victim under 13. Consent is not an element. The law presumes that someone under 13 does not have the capacity to consent to sexual penetration. Are you staying with me so far? And so if you have a perpetrator online who's soliciting, and I'll just use the example of a 12-year-old for sexual penetration, then that's going to rise to a B felony level, all right, because the solicitation is one class removed from your underlying crime. So you can get really close to that, but that's going to be a high release eligibility percentage on any sentence after conviction. And all those other sex offender registry requirements and things are all tied to that as well. So you can get very close. Thank you for your question. Yes, sir.
Earlier in your speech, you said it did not matter the age of whoever possessed the photo of a minor that is exploited or whatever. And so I was wondering why that is such an issue. However, if two minors were to have sexual intercourse, why is that not seen as an issue when that can have a lot more of an emotional toll whenever just having the photos is against the law? But if two minors like were to send pictures of each other, like that's illegal, but if they were to just do intercourse, that's fine. Like I don't see where's the line on that and why.
I think that's a very interesting question. I think that that shows a real comprehensive view of the material that we've covered today. And so we have laws based on what our legislature sees fit to police and punish, for lack of a better word. And so we were talking about age of consent in the previous question, and then 2 questions ago, we were talking about the age gap within which you can consent. I understand. And so the law presumes that if you have, and I'm just going to make up an example, not that we would condone it. If you have an example of 2 14-year-olds, the law presumes that they can engage in consensual sex. However, if one 14-year-old possessed an image that was of the other engaged in sexual activity or simulated sexual activity, then that would make out the crime. 2 years ago, and Judge McKenzie will remember this, we had a question from the balcony about what some states call Romeo and Juliet laws, and that's really related to your question. There's just a legal distinction there, and I may not be able to give you the here's why answer, but any person possessing that image, regardless of their age, regardless of relationship status, has committed that crime.
And I was just also wondering why consent doesn't really matter whenever you're sending photos, but it matters because if they are consensually sending it, like I don't know, I just didn't really.
And so we do live in a very digital age. The question, I don't know if you all can hear up top or not, but the question is tied to consent and why it would apply engaging in sex, but not in the sharing of photographs. And I think that at least our legislature has seen fit to be very protective of those images. I think potentially, possibly the reason is because they're so subject to distribution outside of that. And so I don't know that I can give you a totally satisfactory answer, but that's my best response. Thank you for your question. Yes, sir.
Hello. So my name is Christian Horatio Thomas, and my question is about just a particular situation, if you don't mind.
We'll try.
So.
Don't use any names, please.
Of course, no. It's not a real situation. This is a fictional one.
Okay, thank you.
So if there are, let's say, 2 16-year-olds.
Okay.
Correct. And they are dating each other, they're having sexual intercourse and whatnot.
Okay.
And then they split, and he sends pictures out to his friends, right? and then they send it out more, and then everyone who involved who has that picture is a criminal, right? Because
That's the potential ripple effect that, yeah, Delegate Wayne's question in the
Yes.
beginning was starting to illustrate
So-
for us. Yes, sir.
the question then becomes, what if somebody is just super upset and decides, I'm going to send this to my school-wide class group chat or something? Is everyone in the group chat then affected?
So, all right. The question then becomes, and we looked at our statutory elements. I think that's a great question because we have a situation where images get airdropped or something like that. You have to knowingly possess that. And so if you're a recipient and you're not a willing part of that, you immediately report your receipt of that image. And then it is, I was talking about working with forensics investigators, then the device is wiped or that image is satisfactorily removed, then you're not going to be most likely prosecuted for a violation of that crime. 'Cause you didn't knowingly possess that, right? So there is a fairness consideration when you look at individual facts of any particular case.
Like, just report it and make sure they know.
Yes, that should sort of insulate you from criminal liability under those circumstances. I think at that point, you would be hopefully asked to participate in an investigation to help identify the root of that. Thank you for your question. How are we doing, timekeeper? About 6 minutes. We can probably do maybe 2 more. We'll see how it goes.
Hi, my name is William Bowers. I'm from Elizabethton High School.
Mr. Bowers, good morning.
And one of my questions is, when you have a search warrant for something that's in the internet, is it due to reasonable suspicion or probable cause, or how do you seize that since it's on the internet, or if it's on the phone itself?
So, awesome. That's a terrific question. What is it that you are interested in doing for your career?
As a patrol officer.
Oh, awesome. All right, thank you. So I'll try to use an example of a case that I might handle. One of our slides talked about NCMEC, which is the National Center for Missing and Exploited Children. They are sort of like a watchdog agency, and if they see images online, then they refer those to law enforcement. And so if an image is associated with an IP address, are you tracking with me? Then what the investigator can come to me and ask for is an administrative subpoena to ascertain who the subscriber to that IP address is. And so the question that you've asked is really about burdens of proof. That's reasonable suspicion. We really have a very low threshold to obtain that subscriber information. Now, after we get that subscriber information, hopefully we are starting to wrap our arms around facts that are such that we might have enough to then petition a judge for a search warrant. And under those circumstances, then that's a probable cause standard. That's an awesome question. Thank you very much. One more? All right. Timekeeper's helping me out. What's your name, sir?
I'm Mark McWilliams. I'm from Dixon County High School.
Mr. McWilliams, thank you.
My question is kind of in the same realm as what he asked, but with groups like NAMBLA, how do you guys monitor and ascertain what to do with groups like that?
Okay, now tell me the acronym that you've used.
NAMBLA. It's like the Man Boy Love Association of America.
Okay, and so it's kind of a way to affiliate with like-minded individuals.
Yes.
And you're describing, I'm trying to understand the question, so don't let me put words in your mouth, but you're describing a group that associates for the purpose of pedophilia?
Yes, exactly.
All right, and so we talked just a moment ago about NCMEC. If that group is trading images, soliciting minors, things like that, then that very well could result in what we call a tip, but a NCMEC referral back to law enforcement. That would hopefully be in the jurisdiction where the person soliciting is located. Because you're talking about an organized group, but they could have members all over, right? Or with these cases, they're unique. They can also be prosecuted in the jurisdiction where the victim resides. And so hopefully that's a difficult thing to police. But if there are some basic facts generated in a tip, then specialized law enforcement can probably further that investigation. Thank you for your question. Yes, sir.
My name is Ketron Wells from Ray County High School, and my question is, how do you criminally and in court tell the difference between a guy who has actually solicited a minor or an angry girlfriend who has framed the guy?
Okay, and so your question includes things like spoofing. That's a cell phone. I'm sure everybody knows what spoofing is. Or just trying to frame someone basically online. A good investigation is going to flesh that out. We talked a little bit about metadata and information that can be contained within images and things like that. Your IP address, the address from which communication is sent, can really reveal a whole lot about who the sender actually is. And so we would hope that we would have that question resolved long before a case ever got in a courtroom setting. Yes, sir, thank you. I think last one, what's your name, sir?
My name is Jack, and I was wondering who would be charged if a 17-year-old boy raped an 18-year-old girl?
Okay, so that's an excellent question. I used to handle juvenile court. We have scenarios like that. And we talked about sexual penetration without consent is B felony rape. Do you remember that from a few moments ago? That absolutely could be prosecuted as such. That would originate as a juvenile court petition for the delinquent act of rape, but based on the 17-year-old's age, other facts, a violent crime without consent, what a prosecutor would likely do would be ask the juvenile court judge to transfer that case to criminal court so that 17-year-old could be treated equal to an adult charged with that crime. So in that case, if the transfer was granted, then although he's 17, and I understand your question, I think that's a good question, an interesting question, he could still be prosecuted equally as an adult and have those same consequences. Thanks for your question. Thanks for your time. Thank you very much. Thank you, Kenzie. Thank you.
All right, gentlemen, I'm going to turn it over to the senior, junior counselors. You can take charge of your cities and go from there, okay?